Welcome, everyone. This is Adam Coleman, and with me today we have Jenna Glassock, who is an estate attorney and founding partner at Laurel Trust Law in California. So we're going to talk all about estate planning today. So Jenna, welcome to the show.
Thank you. Thanks for having me.
Well, no, absolutely happy to have you. So before we begin, maybe give a quick overview into what estate planning actually is for the audience.
Definitely. So really at its base, estate planning is just a bundle of legal documents. It's just a bunch of legal documents that when put together, protect you in the event that you are alive but lose capacity, and protect your wishes for after you pass away. So there's typically two parts to an estate plan. The part that I think feels most salient to most of my clients is that post-death part. That's almost always what people come to me asking about. I feel like I need a will because I have kids. I feel like I need a trust because my financial advisor told me to. So that's the part I think we focus on. It's definitely the crux of what we discuss when we do estate planning, but the incapacity part is so important as well. It is so valuable to put in place decisions that govern what happens if you are incapacitated, who's in charge, what your preferences are. So useful to put that in place now. So we always include that in the estate plan also.
How does that work? I guess if you don't have an estate plan, what's worst case scenario that you've seen?
Yeah, with the incapacity planning, there's typically an order of priority that healthcare providers will use for who can make your decisions, kind of a next of kin list. So that's fine, but it doesn't allow you to do everything. And if you do want to get control over someone else's healthcare decision making, typically, at least in California, requires something called a conservatorship, which can be incredibly expensive to obtain and difficult. And so when those documents aren't in place and it's not clear who should take over your care, that could force family or whoever's the right person to care for you into an expensive, lengthy court process. On the post-death side, there's a process called probate. And every state has a different probate. Every state has different priorities, has different processes. But essentially in every state, your closest living relative, whoever qualifies as that in the state that you're in, has to go to probate court and tell the court who's still living, who should be in charge under the order of priority, who should get everything under the priority, and go through that process. How big of a deal that is going to depend on the client situation. Are there minor children? Is there a blended family situation? Stuff like that. And also the state they're in and how onerous probate is. I'm in California. I'm a little biased about this because California, I would argue, has the worst probate system in the country. Most expensive, takes the longest, is all public record, which is true, I think, in 49 of the 50 states. But altogether, California's probate is really miserable. And so I do have clients or potential clients who come to me and say, I really need to do this so the state doesn't take everything when I die. That's not what happens. It still goes to your closest living relatives, but maybe not to the people you want, or not in the way you want, or not controlled by the person you want. And so there are processes for this. They just tend to be really complicated. The one thing I didn't talk about is what happens if you lose capacity, who accesses your bank accounts. That is very difficult. There is no default order of priority for that. That will require a conservatorship, which again is lengthy, expensive, etc. So there could be a real delay in people's ability to access your money and use it to pay for your own care. That can mean missing mortgage payments, missing utilities, stuff like that. And so these documents are really, really important to make sure you're protected.
Gotcha. Okay. So a lot of people think, all right, to avoid all that, I just need to get a will. So obviously that's not the case. So maybe explain why that's not an accurate way of thinking.
So a will is very, very useful for what it's worth. The will doesn't cover anything during incapacity. A will is what we call a testamentary document. It only comes into play at death. That's what testamentary means. And so the will is just a few random pieces of paper during your life. It is meaningless. So it does not help decide who can access bank accounts during your life if you lose capacity, who can make healthcare decisions if you lose capacity, none of that. On the post-death side, it is a very, very useful document to make sure we're not defaulting to the court's rules about who's in charge, who gets everything, and how. It allows you to exert a lot more control. You get to name who's in charge. You get to name who inherits. If we're talking about minor children or people with special needs, or just someone who's an adult and you don't think is great with money, addiction issues, any kind of things, these are very common issues. You can add so much more protection for the people who you want to benefit from your money after you're gone. The one thing the will does not do is avoid probate. So a will, even if done by an attorney perfectly, T's crossed, I's dotted, all of that, wills go through the probate court system. And so how big of a deal that is hugely dependent on what state you're in when you pass away. In addition to what state in which, if you own real property in other states, that can matter too. Like I said, California, really, a will is great, but it still goes through our really onerous, expensive probate court process. Washington, not as bad of a probate process. A lot of people do wills up there. Alabama, I think North Carolina, there's states where it's a really simple, they have summary probate proceedings, kind of shorter, easier probate proceedings. In New York, in Florida, even to some extent in Texas, we really are leaning more on trusts because probate is really onerous. So it really depends what state you're in and the states in which you own real property, whether a will really isn't enough, whether a trust would be more beneficial.
Beyond a will, and then obviously before we get into a full-on trust, what are the other key documents that somebody would absolutely have to have, almost bare minimum, to make sure that they've got their wishes met?
I think the bare minimum is going to be a will, durable power of attorney, healthcare directive, which might be called a healthcare power of attorney, might be called an advance directive, might be combined with a living will. It's different in different jurisdictions. So those documents to cover incapacity as well as the will to cover post-death. That I think is bare minimum. If you're in a state where probate's going to be really annoying, if you own real property in multiple states, then I really do think a trust, and when I say trust, what I'm talking about is what we call a revocable living trust. There are other kinds. Revocable living trust is like our foundational trust. If you're in one of the states with really bad probate, then really in most cases, the trust is the only way to avoid that process for your family.
So, in the states that have a fairly easy probate process, when do people absolutely think that, all right, I need to get a trust, I need to go beyond the standard will, I need to go beyond the power of attorney? When is a trust absolutely necessary for maybe even the easy probate states?
In the easy probate states, for the most part, it's fine. However, probate's almost always public record. And so there are people in our society who will look at every single probate that gets filed to try to sell something to the heirs because they know they just inherited a bunch of money, or try to scam them in some way. So even in states with easy probate, some people choose trusts because of the privacy aspect. Trusts are not public documents. They're not filed publicly. So that's one reason. I think South Dakota is the only state that allows private probate proceedings. So privacy is one aspect. The other is if you own real property in other states. So a probate is necessary in the state in which you passed away, if you own property there, assets there, and in every other state in which you owned real property. So if you live in Washington but have a house in California, you're subject, at least with regard to that property, to California probate and all that expense and time. So privacy, and then if you think you're going to move, right? And so if you're going to go through this whole process anyway, and you might move, or you're thinking about moving to other states, then it might be helpful to have a trust. You don't have to start from scratch when you move. And then definitely if you own property in multiple places.
Gotcha. How about minor children? Like, obviously, a will is not as advanced in terms of directives for money being left to minor children, correct?
Well, you can actually do a lot of the same protection for minor children. So you can have trusts that are created for minor children after you die. You can delay when they get money, all this stuff that we typically put in trust. You can do that in a will. But when you're talking about minor children, then we end up being a little bit more cautious of the public nature, right? The privacy aspects of it. So oftentimes if you're giving all your money to adults and you don't have that much, then you might not care that their information is public. But if it's your kids and you want to protect the fact from it being public record that they just inherited however much money. So I think that's where we lean on trust a little bit more with minors, even in states with really easy probate, is just to get the privacy aspect.
Okay. So I guess the number one issue that a lot of people have with a trust is just that it's expensive upfront, and then it's a matter of maintaining it going forward. So maybe share a little bit about the cost difference between going ahead and having the trust and then going through the probate process if you don't have a trust involved already.
So I always liked when I talk to potential clients or anyone about estate planning, but especially because I'm in California and probate's so horrible here. By the end, it seems like I'm saying a trust is a no-brainer, all good, do it. And I kind of am, but it is really important to know what the downsides to a trust are. And I would argue that there are two. One is that it is typically a little more expensive. There is no element of price transparency on for estate planners because there's so many of us and we're so disparate. And so it's hard to know exactly pricing, but I would guess the difference between a will-based estate plan, the will and all that incapacity stuff, versus a trust-based estate plan. A trust, we always do a will with a trust, and I can get into that, and all the incapacity planning. Probably about $1,000 difference, but that is going to differ drastically by jurisdiction. What state you're in? Are you in a big metropolitan area or a smaller area, right? And so it's going to be widely different depending where you are, but I'm guessing probably around $500 to $1,000 difference, depending on where you're located between doing a will-based estate plan and a trust-based estate plan. The other downside to doing the trust is the way the trust avoids probate is we retitle all of your property, all of your assets from your personal name to you as trustee of your trust. So the downside is not that it will inconvenience you in how you interact with your property. You can buy, sell, invest, withdraw, deposit. You won't even notice the difference for the most part. But there is a short period of time after you sign your trust that you need to spend retitling everything. And so that likely will incur recording fees for new deeds on real property. Out here by me, that's like $30 on your primary residence. In New York, in some areas, it can be over $1,000. So that's going to be a little bit dependent on where you are as well. So there's a little bit of cost involved in retitling real property. And you can retitle bank accounts, update beneficiaries, all of that. But the banks are not super keyed in on this process. And so oftentimes you go to the bank and you say, I set up a trust, I want to retitle my accounts. And they say, okay, cool, no problem. We're just going to close all these accounts and we'll open new trust accounts for you, which might not be a big deal for your savings account, right? Like no big deal. But for your main checking account, that can be really annoying. You have auto pay, direct deposit, everything connected to it. So we try to have some backups. Usually we can list the trust as beneficiary on accounts to try to make that easier. But there is this process involved of having to talk to your bank, deal with your bank, negotiate what they're willing to do or able to do. So that is arguably one downside to the trust. That is kind of a fixed time problem, right? You do it for some period of time. That shouldn't be an ongoing problem because in the future, you want to acquire a new asset, buy a house, open a bank account, whatever it is. You just do it in the name of your trust. You tell lender, you tell your escrow agent, you tell your real estate agent, I want to take title in the name of my trust. You tell the bank, I want to open a trust account. That's all easy. It's just that retitling process that could be a little onerous. So those are the two main downsides to doing the trust.
Ongoing costs. Obviously, you have to maintain it. You have to make occasional changes if you do open up a new account or have the estate planner kind of go through that process. What does that look like just on average? How often are people having to deal with you on an annual basis or beyond that?
Rarely on an annual basis unless the client wants to make regular changes. We try to draft our documents to be pretty flexible. We don't want people having to come in and update things all the time. It's not efficient for us or them. It costs a lot of money. And so we try not to. We try to have backups listed for everything. We try to have flexibility. But life happens. People get older or you get in a fight with someone and you want to restructure who you've named for stuff. And that's totally fine, right? So we can do that as often as clients want. Our policy is we reach out to clients every 8 years. So every 8 years, we just check in and say, don't forget you have an estate plan. Here's a summary of what it says. Is this still the right fit for you? And we feel like that's a good time to check in. People have passed, new babies are born, whatever it is, and we can tweak if necessary. And then it's just usually signing a short amendment or a new power of attorney, which typically shouldn't cost that much. Most attorneys, I think, for that work charge hourly. Rarely takes more than an hour or so. So it's going to depend on what the fees are in your area. But most of my clients do not come in every year. Most will check in every 8 years and maybe they'll make changes every 10 or more. A few clients want to change more regularly and that's fine as well.
What's the main differences between getting an estate plan through you as an estate attorney or going through like one of the online sites like LegalZoom or Trust and Will, things like that, that obviously come across as a cheaper alternative? What are the pros and the cons of that?
I mean, the pro is definitely the cost, right? It is clearly going to be cheaper than working with an attorney for a really customized estate plan. And for some people, that is the right fit, right? For some people, the cost is the most important. Everything they have is going to go to responsible adults where we have no need to protect it or worry about tax issues or anything like that. And so in a small subset of situations where cost is a real issue and we're not worried about extra protections, it might be a good fit. For most people, they think their situation is simple, but there's something that complicates it and they don't realize it. And the problem in my mind with the online systems is that it gives a false sense of security. So people go through, they do it, and then they understandably think, I did it. Great. I'm covered. I've been told to get a trust. I did it. I signed a trust. I have the trust. Mission accomplished. Pat on my back. I'm good. And through no fault of their own, they're often not protected, or at least not in the way that's the right fit for them. I just talked about the importance of retitling stuff into your trust. The trust does not do anything. It does not avoid probate if stuff is not retitled into it. And oftentimes these systems either don't do any of that retitling for you, or maybe draft a deed but don't explain how to record it, or even that you need to record it. Or even if they do that, are not helping you with bank accounts, or definitely are not available when you're at the bank and the people at the bank are being difficult and they don't know what to say or what they're supposed to do. And so there's really no support there in terms of getting things titled properly. And in my experience with them, really not enough emphasis to the user as to how important it is to retitle. This is a really big deal, the retitling part. And so to me, that's one of the biggest problems. The other problem is people really do tend to think their situation is simple. Like they'll come to me and say, we're married and we have kids. It's going to go to the survivor, and then the kids were good. But how is it going to go to the kids? Are the kids minors, right? Do we want to make sure it's protected beyond when they turn 18? 18-year-olds are adults, but they're not, their brains are not fully developed yet. And they just went off to college, and who knows what they're going to do if they, like, a big pot of money lands in their lap. We often like to protect it till they're 25 or 30 or whatever age is the right fit for the clients, but it's almost always older than 18. And so there's those issues. There can be tax issues. There can be money going to their kids who are adults and are so responsible because they're lawyers or doctors or real estate investors or whatever it is, but they're in creditor heavy professions, and there are ways we can protect the inheritance from creditors. So people just don't know what they don't know. And so they come out of this process thinking, it's great, I did it, it feels right, and not realizing that they could have had a plan that was a better fit for their family. And so I'm glad they exist. There is a market for them, and there are people who would not have an estate plan without them. But for a lot of people, it just won't be the right fit for what they need, or it won't be as protective as they were looking for.
Right, because even if they forget one or two things and they don't put in the name of the trust, then they're still having to go through the probate process, and they're still going to have to pay those extra fees. What happens if they do forget anything, or are there things that you just can't put into the name of the trust? Are you always going to go through a probate for small things, or can you avoid it completely?
So ideally, at the end of the day, we've retitled real property, business interests, checking, savings, investment accounts. That might be it. And we're going to update beneficiaries to list the trust either as primary or a contingent beneficiary on retirement and life insurance. The things we do not retitle, debt is the main one we don't retitle. That always stays in your personal name. We're not technically retitling life insurance or retirement. Those are updating beneficiaries, not retitling. Right. And cars, often the DMV has their own process for. And so that's all fine. If you did all of that, you're good. But sometimes we forget our main checking account. We don't realize we're supposed to do our main checking account, or we open an account 20 years from now, and by that point forgot we had a trust or didn't realize we needed to. And that's going to depend on the state you're in. Almost all probate systems that I know of have a minimum threshold under which you do not need to go through probate. In California, our minimum threshold for non-real estate is $187,500. And so I tell clients, if the banks are being really, really difficult, and the one thing we don't want to retitle is your main checking account, and they want you to close it, and that would be too onerous, leave it in your personal name. So long as it stays comfortably under that $187,500, we will avoid probate with it. And that's a different amount in different states. I think Florida is $75,000 if I'm remembering correctly, but it varies differently between states. For those assets, we use what's called a pour over will. And so your trust has all the terms. What we do is we also prepare what we call a pour over will that says anything left in my name at my death with no beneficiary listed, add it to my trust at my death. And so if we are under that $187,500 in California, or whatever the right one is in the jurisdiction, that will add it to the trust without a probate. But if you only have one checking account in your personal name and it's worth $200,000 in California, we are having to probate that one checking account. And on a $200,000 bank account, that attorney's fees alone of $7,000, plus another $7,000 to your executor, plus filing fees and all of that, which are usually around a couple $1,000s. So that's what, $16,000 on a $200,000 account, all of which would have been avoidable if we'd had a beneficiary or retitled. But so there are thresholds if it's small enough, the stuff left in your personal name.
For the checking account, you can just do a named beneficiary, right? Like you're talking about the scenario where they don't have any sort of named beneficiary and it's not in the name of the trust.
Exactly. So often with checking accounts, because a lot of banks won't retitle them, they'll insist you close and open a new one. What we'll do is we'll ask them to add the trust as a pay on death beneficiary. And then it goes to the trust, and we don't care if it's 200,000 or a million, or it doesn't matter. It avoids probate because it has that beneficiary designation. So it would just be things in your personal name with no beneficiary designation, or no valid one if you just list people and they've all gone.
Right. So you could list like a spouse or like a secondary beneficiary as your adult children or whatever like that. That would get around it. You wouldn't have to go through the probate for that piece of it, correct?
As long as one of those people is living. So my job is to be the wet blanket and to be like, okay, what if a lot of bad things happen? And that's why we like the trust, because it has all this contingency planning. So often it'll be like for non-joint accounts, right? List your surviving spouse and then the trust. Or it might be list your surviving spouse, then your adult kids, and then the trust if you can. So we love to throw the trust on there as a last level beneficiary where it's possible.
Gotcha. What if it's just like a lot of different like personal property or something like that? Is that something that you can name individually in the trust? I know you can do it in the will, but is that something that you get involved in with the trust planning as well?
Yeah, so we always include a document called an assignment of property or a general assignment. It's called different things. Usually it's one paragraph, or maybe it's a little longer, that just says all that stuff I own, my furniture, my jewelry, my clothes, whatever, all that stuff's in my trust. So that's our way of avoiding probate on tangible stuff that doesn't have title to it, right? There's no way to prove title. Beyond that, if clients want to specify who gets what, there are two main ways we can do that. We can write it into the trust. We can say, at my death, this family heirloom goes to this person. We also always reference what's called a personal property memorandum, or it's called different things by different people, where clients can handwrite in specific items. So this is only for tangible stuff you can touch. We're not talking about cash. No, well, you can touch cash, but we're really not talking about cash in this situation. But my grandma's wedding ring, you can handwrite it in, who it goes to, you sign it, and that's referenced in your documents as well.
Gotcha. Okay. Well, and I know something that you and I talked about on the mortgage side of things related to estate planning is you were coming into a lot of issues where lenders were basically saying, all right, if you didn't have it in the name of the trust, they were trying to claim that people had to pay the mortgage off in the event that somebody passed away. Is that happening frequently from what you've seen?
It's happening very frequently. So I have clients after a loved one passes away, usually a parent in the situation, and they're going to inherit the house. They get really worried because the accounts often get frozen, especially if we're going through probate. And so they can't access them to pay the mortgage, and they're getting phone calls and letters. And the mortgage company saying, I need to get paid, I need to get paid, I need to get paid. And then we finally get into the accounts, we pay off the mortgage. And then they're like, okay, well, now I have to refinance it. I don't know if I can qualify, all this stuff. But there is a law called the Garden-St. Germain Act that limits the mortgage company's ability to call mortgages in certain situations here. It has to be fewer than 4 units. So it can't be like a big apartment building that you inherited. It has to be inherited by the person who's now going to be the new borrower, who's assuming the mortgage. And the person who's inheriting has to make it their primary residence. So it is a limited situation where the mortgage can be called, but I regularly have this exact situation where they're getting calls about needing to refi and get the mortgage in their own name, whereas that shouldn't be the case here. It should be assumable by the person. There are situations where they don't want to assume it, right? It could be that it's a rate from the 80s or whatever, probably not at this point, but a rate that was really high and they don't want to, but they should be able to, even if they wouldn't necessarily qualify for as good of a rate or something like that on a refinance.
Well, perfect. I appreciate you going through that. So, well, no, this has been great. I know you got to hop off here soon, but I really appreciate you taking the time to go through all this. I know you're obviously in California, but you have a network of other estate planners if anybody's in other states that would also like to get information. So, what's the best way if they wanted to get more information on you or estate planning in general? Where should they go?
So our website is ltlfirm.com. The LTL is short for Laurel Trust Law. So www.ltlfirm.com. We have a bunch of stuff on our blog about some of these topics. Our contact information is there. Me and my partner, Kelly, she's also in California. And we have a collection of co-counsels in other states, and their bios are on there as well. And so lots of information there, and people are always welcome to reach out to me or Kelly if they have questions or if they want a referral to someone in their area. We regularly provide referrals all over the country. So we're happy to talk to anyone who has any questions.
Perfect. And I'll make sure to include that website on the description as well so that they can reach out to you. But no, this has been perfect. I really appreciate you taking the time and kind of giving us some more education on estate planning.
Awesome. Thanks, Adam.
Oh, no problem. Thanks, Jenna.